Absolutely. Depan. To side पे आती है। हाँ, वाह।
Or orders, item number 1.
These my lordships. Yeah. The last order, my lords, this honorable court has given 3
Months time to them.
months time to be respondent government.
Yes, who is for the state?
The Ranidhi ji.
Yeah, Mr. Advocate General.
My lord, in fact, I was to report to your lordships,
My lord.
and I'm happy to inform your lordship that yesterday the notification has been issued.
Where is that notification?
I'm just placing it on record for a minute, my lord. In fact, the notification has got.
Mr. Balgopal, you are not audible.
Oh,
Yeah, now you are audible.
okay, please, ma'am. Which so, please, my colleague is passing it on to your lordships.
It is. Yes. It is honorable. Yes, counsel for the petitioner,
Lordship,
what do you want to say now? They have
submission to Chief Justice.
Would you like to offer some comment on it? So, if it is possible, we can place it tomorrow.
Lordship,
Okay?
Lordship.
I will appear tomorrow, my lords.
Yeah, certainly.
I will appear in person. Today I have the border dispute.
Yeah,
So in
yeah.
the night I reach Gauhati, overnight I will be there.
Okay, okay.
And also, my lord, with your lordship's kind permission,
Yeah.
we are filing two transfer petitions of two matters.
Fine.
Your lordship may only direct that may also be listed subject to your lordship's convenience tomorrow. Brief petitions.
List those
Great.
transfer petitions also.
I'm grateful.
We'll
Right.
get it.
Agree. My lord, this one, I just wanted to point out,
Yeah,
in 2006, when this issue came up and we had agreed for the separation
yeah,
before Justice Sudarshan Reddy at that time,
fine.
that time we had a discussion, this was issued, and we had a friendly discussion with the Honorable Chief Justice also to point out some of the small print picks apart from the main issue.
Yeah,
As far as this notification is concerned, that is final. Now, since they raised the issue of superannuation, this thing, we will have a amicable discussion, which is not contingent on this notification.
so when you are going to enter into this discussion,
As is convenient to your lordship, that has nothing to do with the notification.
Balgopal?
Notification stands.
yeah,
That stands. That stands. There's no second opinion about it.
fine.
So that is final. Signed, everything is through. I've done all this from direct instructions from
You
the.
are not audible.
I'll be audible tomorrow, my lord. Give me one.
Okay, fine.
I'm grateful.
Take down. This court by the order dated 24th of August 2021 granted 3 months time to the state of Nagaland to comply with the order dated 25th of August 2020. Will stop. Pursuant to that, Learned AG has placed on record a notification dated 27th of September 2024 and has submitted
29 September, my lord. 29.
29th, sorry, 29th,
Yesterday.
2024, and submitted that the state of Nagaland has agreed to transfer the administrative control of 211 district court employees under the control of the Gauhati High Court with effect from 30th of January 2025, with a mention that it shall be issued in the first week of October 2024. It is further mentioned in the notification that the issues pertaining to the age of superannuation in terms of the Nagaland retirement from public employment in bracket second amendment bracket clause Act 2009, the pay structure shall be amicably discussed with the Honorable Chief Justice. Honorable Chief Justice, full stop. The notification dated 29th of September is reproduced here under. Full stop. Then counsel appearing for the petitioner praise a day's time to go through the notification. Full stop. In view of the above, let this matter tomorrow.
Lordship.
That is on students.
Right.
Item number 2.
Please, Lordships,
Yeah.
Lordship, I'm appearing on behalf of my seniors and my Lordship. My seniors have some personal difficulties, so I pray that this matter may kindly be listed after one week. Lordship.
Who is appearing for the appellant?
Places for individual of the Ministry of Business, they have not made in the Ministry of Home.
How it matters? You are appearing for the central government?
Yes, sir.
So how it matters, either you appear for the home department or the defense department, responsibility would be the same.
Yes, that's
So now you are for the petitioner or you are for the petitioner?
Yes, Your Lordship.
So what's wrong in the order of the tribunal? What's wrong in the order of the tribunal? You were discharged on your own request, and you have admitted in so many terms in this writ appeal also that you have requested orally for voluntary retirement. The counseling was also conducted, and thereafter this application was accepted. And you yourself has moved an application for this whatever the dues you have been paid according to that. And you were discharged in 2015 and you approached the tribunal in 2019. What is there on the merits? We don't find any case for on merits also. Now you are trying to take you have taken a altogether new ground regarding this mental disability or mental problem. That was not either before this tribunal. That was not taken before the tribunal. Tribunal simply your case was that you were forced to sign some papers. That's all. We don't find any. Where is your senior?
there is no forcing the Commissioner to sign.
Where is your senior?
Lordship, my senior has some personal difficulties today, so.
So okay, we'll place it tomorrow. Ask your senior to appear tomorrow.
Lordship.
Counsel for the petitioner has submitted that the arguing counsel has some difficulty to argue the matter today. Today, full stop. The matter comes upon for consideration of the IA number 125/2024, wherein the petitioners have prayed for substituting substituting respondent number 1 as Ministry of Home Affairs to Ministry of Defense. Full stop. Learned counsel for the respondent has no objection if the prayer is allowed. In such circumstances, the prayer for substitution of the respondent number 1 is allowed, and the in place of Ministry of Defense, the Ministry of Home Affairs, Ministry of Defense be included as be substituted as respondent number 1. Amended cost title. You were supposed to file an amended cost title.
Yes, Lord.
Then counsel for the petitioner is directed to file amended cost title during the course of the day, today itself, during the course of the day. Mr. So and so appearing on behalf of the central government, accept notice on behalf of the substituted respondent number 1 to establish this matter tomorrow.
Let me obey.
For admission, item number 3.
This is Lordship, the IA 17 of 2024, it's filed for staying of the impugned judgment order that the 22/2/2024 passed by the Honorable and Civil Judge.
When this order was passed,
Lordship, the order was passed on 22/2/2024, my lord.
fine.
Lordship will find
What
that,
are, what are your grounds for stay?
Lordship, the ground for stay is that the works orders that was awarded to the petitioner, petitioners, Lordship, was issued by the state government implementing the project sanctioned by the central government.
Where is that government order, 10th of April 2000?
10th of April 2015, my lord.
Where is the
Lordship,
page number?
Your lordship will find that at page 59 of my
59.
real bill.
There are 5 work orders.
The 5 work orders start on page 36, my lord.
4th of, that is
With memorandum.
not
fourth of-
59, not
Yeah.
59.
Page 36.
Page
No, work order starts from page 36, my lord.
36.
Yes, ma'am.
Yes, yes. So from there it is reflected from this work order that this work orders in relation to
Yes.
some work which was sanctioned in the state government central government scheme.
Yes, my lord.
Where is that?
Your lordship, the work order says, if I may be allowed to read the subject part only, just the subject part.
Read.
Work order for the constructions of approach road connecting government higher secondary school to Sumogitima. Yes, package 1. Now the work that was sanctioned by the central government through its office memorandum 43/2014 clearly reflects the project.
Where is that?
Lordship, at page 59 of my read with the lordship, the type copy, your lordship will find it at page 61.
Yeah, read.
Yes. Lordship, this is the order office memorandum
March
issued
of
by the,
March of 3rd of March 2014.
yes,
Read.
yes, your lordship. The subject, release of additional central assistance to Nagaland for urban infrastructures development under UIDSSMT schemes during 2013-14 transition phase of JM Dharam, your lordship.
Fine.
Your lordship, para 3.
Yeah.
As per the decisions of the Cabinet Committee of Economic Affairs on 17/1/2013, the following projects may be considered for release for first installment of ACA. Your lordship, on the next page. On the next page, there are 2 project components shown, your lordship. We are concerned with serial number 2,
Yeah.
lordship. Name of the town, your lordship, Sumogitima. The next column is the project component road, your lordship.
So where is the specific that this road 10/4/2015 says,
Yes,
that is at page 36.
yes,
Construction of approach road connecting government and higher secondary school to Chukema package 1.
yes,
Where is that? Chukema road, simply you have mentioned that roads, that
Yes.
nothing else. Which road you have not specified?
yes.
How many roads are there in this town?
Your lordship.
How many roads are in there in town?
Your lordship.
Only one road.
No, your lordship, there will be plenty. However,
You should have specified it.
yes, however, your lordship, in the affidavit filed by the Union of India,
Yeah.
they have admitted.
So the Union of India, where is that sanction? The Union of India that this particular road is sanctioned under the central government scheme, you just show us from their affidavit.
Yes, your lordship.
Yes.
Allow me to take my lordship to the,
And the learned single judge has kept it open for the state of Nagaland to realize the money from the this central government because
yes,
the contractor has completed the work in August 2015 itself.
correct.
And he is being deprived of, despite execution of all the work, he is being deprived of payment.
Your lordship,
What is his fault?
yes.
What
I
is his
agree.
fault?
I agree, my lord. However, your lordship here, the liability does not only falls upon the state government, the liability falls as on the union government.
That's why only the learned single judge has made it clear.
Yes,
Read in the last para.
yes, your lordship. I
Read in
agree
the
with my lord.
Read in the last para.
Yes, your lordship.
This court has noted whether the state Nagaland would be entitled to claim such amounts from the so and so, the Ministry of Urban Affairs, under such shall be open for the state to pursue such remedies against the respondent in respect of amount which The respondent number 1 to 4 has been directed to pay. Then
Correct,
you take, why this person, contractor is going to be suffer?
Lordship,
Why he
Lordship,
should suffer?
Lordship, in this connection, allow me to make one submission.
Fine.
The project that was dropped
Yeah,
by an office memorandum 14/8/2015.
yeah.
Your Lordship, para 6, Your Lordship, if I may be allowed to read this, my lord.
Yes. Page number,
Page number, my lord, starts with, Your Lordship, starts with page number 63, the type copy, Your Lordship, is at page 71. The relevant portion, Your Lordship, is at page 74. Page 74, the relevant portion, Your Lordship, the relevant paragraph.
yeah,
B. All projects, the first paragraph, my lord, all projects that start with all projects which were approved but fund could not be released as on 31st of March 2014 stands dropped and will not be considered for funding.
right, sir. But in that order, they have not tackled with the eventualities where the work has already been completed.
Yes,
Yes, then what?
the work is completed.
So
Your
what is the fault of this contractor you just show us?
No, Your Lordship,
And it is open for you to realize the money from the central government, because since the work was completed prior to issuance of this. So give us the money of the central government,
I agree, Your Lordship, however, this
and if the
office,
central government fails to pay, so avail your remedies.
Lordship, the office memorandum clearly says that it will not be considered for funding anymore.
Sir, that order is dated
The order is dated 14th of August 2015, my lord.
and prior to that, work order was issued and he has completed the work.
Correct, correct,
Executed the work. Then
correct.
why he should suffer?
And the work was implemented on the basis of.
It is not your case that the work has not been completed to the satisfaction of the government or whatever.
Yes,
Then
Your Lordship, it was implemented on the basis of the state share as well as the central share, Your Lordship. Now the central government is not releasing its share. So Your Lordship, this appeal petition is not that we are not saying that we will not pay, but we are supposed to pay only the share that we are supposed to.
whatever it may be, once it is, the road is in the state of Nagaland only,
Correct,
used by the people of the Nagaland,
correct.
pay the money. That's all. We are not supposed to. Can't pay.
Lordship,
I go to union up here.
Most welcome.
Yeah.
The same argument is also there. Most welcome.
Let me like your attention to my athlete. I in the single bench, I have my.
Whatever it may, you just tell us one good reason why this person who has executed the work as per the order of the state of Nagaland has executed the work, why he is deprived from that money.
Why it is being developed, that is why I'll just.
The same reason, because the central government has withdrawn all the
Yes,
projects
it's a-
which were approved, but funds could not be realized. 31st of March stand drops and will not be considered for funding. That is between
Almost
you and the, that is between
Almost
you.
1 year after transition phase, without any consultation of the Ministry of Housing and.
So raise this,
The state government, they have.
raise this issue with the central government, pay him.
Yes.
That's all.
Yes. In paragraph 14 of the judgment of the.
Now you are arguing contrary to that. Now you are saying yes.
No, Your Lordship, our prayer in the written petition.
You are for whom?
I'm for the state, I'm for the MLS.
State, the amount is directed to, the Leonard Singles is directed to pay the amount to you only.
And therefore, we have made a prayer, Your Lordship, in our,
How you are aggrieved by this order, sir?
I'm not agreed, but since they have an agreement, I'm making my I'm deciding the regulation.
Whatever it may be, whenever they raise an issue with the central government, yes, since this work was already executed and the payment is to be made, we have already made the payment, realize that money, you consider it and give it. It is always open for you. What happened?
Lordship, the only prayer that that the appellant have, Lordship, in this case, is that since now the office memorandum 14/8/2015 clearly says that it will not be considered for funding. We have in fact wrote a letter earlier also to the central government. However, they have.
Where is that letter?
Your Lordship, that
Let the central pay, let the central, state government pay and leave that. Because.
Not there.
Yes,
Lordship. Lordship, in our affidavit in opposition, we have.
we agree, sir.
Yes.
We agree that you are saying that it was under the central scheme, but since the central government after this 2014, from August 2014, they have withdrawn all that, whatever the sanction amount and specifically made it clear the money which was not released up to 31st of March 2014 shall not be funded.
Correct,
Absolutely right.
correct.
Everything is right.
Correct.
But since you have passed an order and given me a work order,
Yes.
he has executed the work.
Correct.
What is his fault?
Correct, Your Lordship.
You raise this issue with the central government that since this work was already executed and we have made the payment to the contractor, you realize that amount was, they'll consider it.
Your Lordship, in fact, that issue we have already said in our affidavit in opposition also, Your Lordship.
Okay, fine.
Categorically.
Categorically, then if the state government, the central government is not heeding to your request, then avail your appropriate remedies available to you. Avail the appropriate remedies against the central government.
Your Lordship, if the order can be modified only to that extent,
What?
only to that extent, Your Lordship,
What?
that the Union of India,
Hmm.
who is the concerned department or the respondent,
Fine.
because of which we have issued the work order, if they are made to pay, or if the state, in case of the state seek remedies by asking the Lordship the amount from them, the Union of India should take that into consideration. If that's.
So that is already there.
Well, that is already considered.
Yes, sir, we have asked you. We have then sit down. Don't you argue in between. Yes,
Or only to that extent, Your Lordship, because Your Lordship, our.
sir, that liberty is already there.
Your Lordship,
That liberty is already there.
in fact,
Just come to last para.
yes, Your Lordship, I agree with that, my lord. However, Your Lordship, if maybe I may be allowed to make one small submission here, Your Lordship. In fact, in earlier times also, though of course we have not annexed it here, it is on record in the repetition, Your Lordship. We have wrote a letter to the Union of India, not only once, but on 2-3 occasions.
Suppose if the
Yes, however,
Union of India is not paying, you are paying any heed to your request,
yes.
then what remedies are available to you?
So Your Lordship, here.
What
is-
remedies are available to you?
Lordship, then in that case, Your Lordship,
Avail that remedy. That's all.
Your Lordship, otherwise, Your Lordship, we are not disputing that we are not supposed to pay. We are not disputing that.
Then why are you contesting?
We are disputing.
If you are not
only-
disputing and you are that you say that you are entitled to, you are supposed to
Yes,
pay it.
only that stage here.
Yeah,
Only the stage here. Because your lordship, the office memorandum 2014 also speaks about the state as well as the central share.
right. Thing is that this person has executed the work way back in the year 2015. Why he is being deprived for that? At the best, we can do that without
Yeah.
interfering in the order. We'll say it would be open for the state government to make a request for realizing that amount which the respondent state is going to pay to the petitioner, and the central shall consider the same objectively expeditious. That's all.
Lordship, otherwise, our prayer in the read also is limited, very limited. Your Lordship.
That we are
We
not
have-
going to grant.
Yes,
We are not going to grant.
Your Lordship.
We are not agreeing to that.
Lordship, yeah. If some relief, your lordship, can be granted. to
Yes,
this-
this relief that you ask the central government to pay the reimburse that amount which you are going to pay to the contractor. The central government is directed to consider the same objectively and expeditious.
Lordship,
That's all.
lordship, that would,
So you would be satisfied with this direction?
yeah, lordship, because our limited prayer is only that, just to modify the court order.
What modification you are seeking?
Only to the extent that the state, the liability that is upon the, yes, upon the Union of India.
That we are not going to do.
Yes.
As well of the civil bench, they have been given a liberty, recognize the same. Or putting up the judgment, the civil bench, as they that, these are the order to the state government, on our right to pursue.
Mr. Consul, you have to answer some questions. You have to answer some questions. This project was, whatever the project was in sanctioned in the March or somewhere in 2014. Somewhere in 2014, and after more than a year, now you have clarified we are not going to give you the money. Why?
On 2014.
Under that impression, the state government has issued the work order. Then at least the works which has already been started or executed, for that, the liability of the central government is there.
No.
You can't deny that liability.
The project was dropped on 2014.
No,
No, Lordship, it was dropped on 2014. And the work order was given to the petitioner on 2015. So I am saying, why? My lord, can it come to my affidavit? Page 79. That is my affidavit and 80. Page 80.
79.
79, and the relevant portion is page 50.
Read,
Paragraph.
yeah,
That it is first that the Ministry of Finance did not release funds for the instant project, Gauhati project, along with some other project. The project therefore stood drop for funding by the central government right from 1st April 2014. The state government was well aware that the fund has not been released for the said period, and transaction phase has also ended on 31/3/2014. The said project was therefore not at all eligible for the funding of the government of
so
India.
when you have dropped those,
Yes.
when you have decided to stop that funding, when you have decided,
It will be in page, para 3, page 80. Page 80.
when,
Page 80, page 80, para 3.
page 80 para 3,
yes.
yeah,
That is first stated that the Jawaharlal Nehru National Urban Renewable Mission so and so was implemented by government so and so. For 7 years, beginning from 2005 to 6, the set was extended from 2012 to 2014.
Fine.
So it was only
when
2014.
you have informed the state.
So it was only 2000, it was only 2014, but
Just a minute.
Contract was given
When-
after 2014.
When you have informed the state government that now we are not going to fund you anymore in respect of those funds which were sanctioned or those projects which were sanctioned in 30th of March 2015, when you informed the state government,
In 2014, also.
No.
There was draw in 2014.
you,
We had-
you have
But the
informed
work was again extended.
you have
in
written the
2015.
letter to the state government or advisory, whatever it may be, on 4th of August 2015 for the first time.
No,
Prior
no,
to
no.
that, the work order was issued.
This is not only with regard to state of Nagaland. Actually,
We understand.
this
that.
is regard to the almost the.
We are
Not-
concerned
not
with
state.
this project only, that's all.
So we have already dropped the scheme. But in spite of which, the state government, we have given the work order.
Yes, that's all. This writ appeal is filed by the state of Nagaland being agreed with the order dated 22nd of February 2024, whereby 24 in WPC number 86/2019, whereby the learned single judge has disposed of the writ petition filed on behalf of the private respondent with the direction to the state of Nagaland to disperse the amount of rupees 18,70,250 to the private respondent within a period of 4 months from the date of certified copy of the order is served upon respondent, served upon, who is the respondent number 3?
Respondent, your lordship, 1 to 4.
No, just a minute.
is,
To the director,
Yes,
Directorate of Municipal Affairs, Nagaland, Kohima. Full stop. The learned single judge has further observed that if the respondents fail to make the payment within the stipulated time, they shall be liable to pay interest at the rate of 7.5% per annum from the date of default. That is from the date of expiry of 4 months from the date of service of certified copy of this order. The learned single judge has further kept it open for the state of Nagaland to pursue its remedies against the respondent number, against the central government in respect to the amount which the respondent number 1 to 4 have been directed to pay. Full stop. Para. The facts, the relevant facts of the case are that the state government has issued a work order dated 10/4/2015 to the respondent construction firm. It's a construction firm.
yes, your lordship.
To the respondent construction firm, to the respondent number
1 hearing.
Respondent number 1 construction firm to execute the construction work of the approach road comma, details of which has already been mentioned in the impugned order. Full stop. The pursuant to the work order, the respondent number one has executed the said work in the month of, when you have executed this work,
Lordship, before the expiry of the 6 months' time that was given to them in the work order, Your Lordship.
within the time limit granted to it. However, no payment for the said work has been made to the respondent number one. Full stop. Being agreed with the same, the respondent number one has approached this court by way of filing, approached the writ court, and the writ court, after hearing the counsel for the parties, has passed the impugned order. Full stop. The learned single judge has taken into observation, has taken into consideration that the state government has issued the work order to the respondent number firm, and it has successfully executed the said work. Full stop. It is also taken into consideration by the learned single judge that the state government has shown its ability, shown its inability to pay the work for the execution of, to pay the amount for, amount in lieu of the execution of the construction of roads by the respondent number one, on the ground that the works were, the construction of road was executed under the central government scheme. However, the central government scheme, however, later on the central government, by the order dated 4/8/2015, has withdrawn all the said funding for which the funds have not been approved up to 31st of March 2014. Full stop. The learned single judge has also taken into consideration the stand of the central government and has opined that from the work orders issued in favor of the respondent number one, it is not demonstrated that the said work orders were issued in pursuant to implementation of the central government scheme. And therefore, the state is liable to make the payment for the executed work to the respondent number one. Full stop. Learned counsel for the appellant has tried to emphasize that, as a matter of fact, the work which has been executed by the respondent number one were under the central scheme only, and not under any scheme of the state government. It is also contended that, as per the central government scheme, the 90% of the cost of the project is to be paid by the central government, whereas the state is only liable to pay 10% of the cost of the works executed. It is submitted that state government is, it is submitted by the counsel for the appellant that the state government is ready to make the payment of that 10% amount for which the state government is liable. And a direction be issued to the central government to make the rest 90% of the, to make the payment of rest 90, remaining 90% amount. Full stop. Para. Having heard the learned counsel for the parties, and after taking into consideration the overall facts and circumstances of the case, we are of the view that the respondent number one contractor has successfully executed the work pursuant to the work order issued by the state of Nagaland. It is not the case of the it is not the case of either state government or the central government that the work has not been executed by the respondent number one. In such circumstances, we are of the view that the learned single judge has not committed any illegality in directing the state government to make the payment of the work executed by the respondent number one within a period of 4 months. Within a stipulated time, full stop. We are also, it is stipulated time while granting liberty to the state government to pursue its remedies against the respondent number five in respect of the amount which the respondent number 1 to 4 have been directed to pay. Full stop. In such circumstances, we don't find any case for interference. However, it is observed that if the state governments moves to the central government for reimbursement of the amount which they have been directed to pay to the respondent number 1 to 4, it is expected that the central government shall consider the said request objectively and expeditiously. Full stop. It is further made clear that the time for making payment to the respondent number 1 by the state government is extended for 3 months from today. Full stop. If any 3 months of today, with the condition that if the respondent state fails to make the aforesaid payment, it shall liable to pay interest of 7.55% per annum from the date of default. With these observations, the writ appeal is dismissed. IA is also dismissed.
In the writ appeal,
IA is also disposed of.
in the writ appeal, there is no respondent number 5. In the writ appeal.
Central government, we have not mentioned respondent number 5, we have simply said central government.
Right.
And we'll take care of that. Item number 4. Yes.
What's my paying for the private respondent number 4? Matter might be taken up for period of 2 weeks.
Right. Yes, what do you want to say? What about this status quo? Who is working where?
Both the appellant and the respondents are working in the same college in view of the attachment order.
How can it be? How can
Respondent
it?
number 4 has been adjusted on a vacancy which was lying vacant in view of the study leave of the officer.
So both of you want to remain in either Kohima or in Dimapur. Nobody wants to move out of these two towns.
Of the appellant, Lordship.
Nobody wants to move out of these two towns.
No, Lordship, the appellant is
And
Questioning
you,
the
you,
legality.
you were working in Dimapur since long?
no,
Since when?
Lordship.
13 years.
No, Lordship.
13 years in the
Since my
same place.
appointment, I was posted at Wongkau College, Bonn, Lordship.
You are in Dimapur since long? Since when? More than 13 years. The request of the concept of the respondent, private respondent, list this matter after 2 weeks. You need to, that's, you are working from the, there in, from last,
Lordship, present in the
More than-
respond, then maybe continue.
so that is not limited. If you want, we'll get it limited.
Till the next day, Lordship. That is the order passed on 7/24. 7/8/24, Lordship.
Interim order passed by this court on 7/8/2020 shall remain in currency till next date.
Public.
For hearing, item number 5.
May I please, your lordships?
Yeah.
Lordships, I humbly beg to mention on behalf of my senior AGO lordship.
Yeah.
Lordship, due to some unavoidable circumstances, and also the passing away of his,
You
family
please
members.
explain those unavoidable circumstances.
Lordship, due to the sudden demise of his.
But unavoidable circumstances, he didn't wish to come to the court. That is the unavoidable circumstance. Or what else?
Lordships here, my senior had to accompany the dead body, to the.
Somebody else.
Lordship, lordship.
Okay.
So lordship,
Just after 2 weeks. Because then the concept of the concept of the appellant has submitted that the arguing consent.
no. You representing Mr. Joe.
So you are for the respondent.
Lordship, lordship.
Okay. Learned concept of the respondent in this writ appeal has submitted that the arguing consent is not available today due to bereavement in his family. And therefore he has prayed for adjournment, list after
Much,
4 weeks, list after 4 weeks.
much obliged.
Item number 6. Where's your jacket, miss? Where's your jacket?
I'm advising your, I just came late and started. I forgot.
So came late, then why you wearing this shirt also? If you are so late, you should have come bare chest.
I apologize your lordship.
Where is that? At least you should come in the uniform in the court. You are appearing before the High Court. It's very easy to wear a gown and without being jacket. You are practicing since when? You are practicing since when?
2006, your lordship.
So every day you are appearing like this in the court.
This is the first time.
You are central government concern.
Yes, lordship.
Sir,
Your
you are
lordship,
central government concern.
I apologize for that. Actually, just now I reached. So I'm just out of my mind. It came, your lordship. It is helps.
Very great. It's even out of mind to wear the jacket. And how you wear all this pant and shirt? You forget that. It's too much. Yeah, what do you want? What do you want?
Lordship, I will just change and come.
Nothing. Okay, then council appearing for that. Deputy General Manager, State Bank of India, is not in proper uniform, and therefore we refuse to hear him. This after 4 weeks. Don't take it is so easy. No, this is absolutely unacceptable. This, in your, particularly when you are for the Union of India, it is not expected from you. It's absolutely bizarre. Yes,
I will want to apply here, we listed tomorrow before your vote, because.
what's the urgency in that?
My lord, the order is to advertise the post held by the president. Appel,
The order to advertise the post.
yes,
What happened in the before the learned single judge? It is an appeal
yes,
against the order of the learned single judge.
yes.
Learned single judge has dismissed your writ petition or allowed writ petition of other party.
It is in favor of the public respondent, practically. Otherwise, I approach the registry, my lord. Since it is
Let's
case
tomorrow.
must order,
Tomorrow.
much of that, much of us.
Oh, they will be not.